In this video, I'm going to explain how Florida's new condo safety laws are triggering more construction defect litigation. I'm Santiago Cueto, board-certified international business law expert and best-selling author. Right now, condo owners across Florida are opening letters that are changing their lives. These aren't HOA notices about pool rules. They're million-dollar assessments. They're litigation notices. They're documents telling them that their building might not be safe. And it all traces back to laws that were supposed to protect them. Florida passed sweeping condo safety legislation after the Surfside collapse. The goal was noble: make buildings safer, catch problems early, prevent another tragedy. But here's what nobody predicted. These laws didn't just find safety issues, they opened up Pandora's box of construction defects that were hiding in plain sight for decades. Defects that might have stayed hidden forever. Now they're all coming to light all at once, and the litigation is just beginning. I've been sitting across the table from condo boards, developers, and contractors for weeks now. What I'm seeing is unprecedented. Let me explain what's actually happening on the ground. You see, after Surfside, Florida didn't mess around. The legislature passed some of the strictest condo inspection requirements in the country. Buildings over 3 stories now need milestone inspections. These aren't casual walkthroughs. We're talking about structural integrity reviews by licensed engineers and architects. They're looking at concrete, rebar, waterproofing, load-bearing walls, everything. And here's the critical part. These inspections have deadlines. Buildings that are 30 years old or older near the coast have to be inspected. Buildings that are 40 years old inland have to be inspected. The timeline is tight. The penalties for non-compliance are severe. But that's just the inspection. The real bomb drops when the engineer files their report. If they find substantial structural deterioration, the clock starts ticking. The condo association has a year to start repairs, not to finish them, to start them. And this is where everything falls apart. Because when you start pulling back walls and cutting into concrete to make these repairs, you start finding things. Things that were never built right in the first place: improper drainage, missing waterproofing membranes, inadequate rebar spacing, concrete that doesn't meet specifications. These aren't new problems from aging. These are construction defects from day one. Now you might be thinking, why does this trigger litigation? Can't associations just make the repairs and move on? Not when we're talking about millions of dollars in repairs that shouldn't be necessary in the first place. Now let me walk you through what happens. An association gets their milestone inspection. The engineer finds substantial structural issues. The board gets bids for repairs. The bids come back at $3 million, $5 million, sometimes even more. The association has to do a special assessment. Owners are hit with bills for $30,000, $50,000 per unit. Those owners start asking questions. Why is this building falling apart? We paid good money for these units. Someone built this wrong, and they're right. When the engineer's report shows that the water has been infiltrating the building for 20 years because the waterproofing was never installed correctly, that's not an aging issue. That's a defect. Someone is liable. So the association hires lawyers. They start looking at who built the building, who designed it, who supervised construction, and they file claims. Breach of contract, negligence, breach of warranty, violation of building codes, the whole playbook. If this information is helping you understand what's happening with Florida condos right now, do me a favor and hit that like button and subscribe to this channel, because this situation is evolving fast. I'll be breaking down every development as it happens. Now here's where it gets legally interesting. Florida has statutes of limitations on construction defect claims. Normally, you have a limited window to sue after construction is complete. For many of these buildings, that window closed years ago, decades ago. But these new inspection laws are creating exceptions. Courts are starting to see arguments that this discovery rule applies. The defects weren't discoverable until these mandatory inspections forced associations to look further. Some associations are arguing the statute of repose should be tolled because the defects were fraudulently concealed. Now, these are novel legal theories. We don't have clear precedent yet, And even if the original developer is unreachable or judgment-proof, associations are going after everyone else. The architects who stamped the plans, the engineers who certified the structure, the contractors who did the work, their insurance companies, and anyone who touched the project. The insurance industry is bracing for impact. Some carriers are already trying to deny coverage. They're arguing there are maintenance issues, not sudden occurrences. They're claiming policy exclusions apply. This is creating a second wave of litigation between associations and insurance. All right, so what does this all mean for condo owners and developers? For owners, you need to understand that these inspections are coming whether you want them or not. If your building is approaching that 30 or 40-year mark, start preparing now. Get on your association board, ask questions, review your reserves. Don't wait for the inspection to blindside you. For developers and contractors, this is your warning. The work you're doing today will be scrutinized decades from now under a microscope. These new laws aren't going away. Florida is serious about building safety now. Document everything. Follow specifications exactly. Don't cut corners because the association might not catch it during construction. They'll catch it 30 years later during a milestone inspection, and you'll be answering for it in court. We're all seeing a shift in how new construction contracts are being written. Developers are trying to add protective language. They want shorter warranty periods, limited liability clauses, mandatory arbitration, but buyers and associations are pushing back. The negotiating landscape has completely changed. The collision between Florida's new safety laws and old construction defects is just beginning. We're going to see years of litigation from this. Billions of dollars are at stake. Buildings that looked fine on the surface are revealing problems that should have been caught decades ago. Now, if you're involved in this space as an owner, board member, developer, or contractor, you need to understand what's coming. Now, if you found this breakdown valuable, make sure to like this video and subscribe to my channel. This is the developing story. I'll keep you updated as these cases move through the courts and as new developments emerge. I'm Santiago Cueto, your Florida business law attorney. Be sure to stay and watch more of my videos right here.